Well, what is medical negligence? I mean, is medical negligence the same as any sort of medical mistake?
It's very important that we prove everything. We have to prove everything.
So another common misconception I think that many clients have is that their case inevitably has to go to court. Is that true?
The clients that come to us will pay nothing unless the claim is successful.
I mean, some people feel that awards of compensation for personal injuries and for medical negligence are a bit of a windfall. And what would you say to that?
We're seeking to have a wrong put right financially the only way that it can be.
Hello, and welcome to today's episode of Medical Negligence Matters. Today we're going to be looking at some of the misconceptions in medical negligence and trying to debunk some of those errors in thinking that occur within the field. And with me today to talk about those things is Corrina Mottram. Hello, Corrina.
Hi, Gillian.
And so the first thing I wanted to think about was, well, what is medical negligence? I mean, is medical negligence the same as any sort of medical mistake or...
No, certainly not. There are all sorts of things that can go wrong, in inverted commas, in treatment that aren't negligence. There's quite a high bar for something to qualify as medical negligence. It has to be something that was done or not done that no other competent professional would have done or failed to do. So simply, a small error in judgment or a misreading of a result that's not necessarily particularly significant won't necessarily be negligent.
So a mistake isn't necessarily negligent,
No.
And it's up to the individual claimant to prove that what happened to them was something that isn't just a mistake, but it was something that was, as you say, outside the boundaries of what is acceptable medical practice in the minds of all competent clinicians.
Exactly that.
And what about the claims process? I mean, a lot of people believe that the claims process is quick and easy.
Sadly, that's absolutely not true. It's a really common misconception. Clinical negligence claims, medical negligence claims in particular, do take a very long time. There's a real forensic examination of medical records by both experienced solicitors and then by experts.
So why does it take so long?
I think it's very important that we prove everything. We have to prove everything. The claimant who wants to bring a claim has to jump through an enormous number of hoops, and each of those hoops can take time, sadly. And so it's not unusual for a clinical negligence claim, even in relatively straightforward circumstances, to take a couple of years. We often warn clients that they can take 3, 4, 5 years, even in relatively straightforward circumstances. And some claims involving children may take many years because we need to see how the child progresses and make sure that we've understood all of the implications that the negligence might have had for them.
So the fundamental is that it is quite a complicated process. As you say, the burden is on the claimant to prove their case at every single step. And I suppose each step in the process, from obtaining the medical records, obtaining independent expert opinion, dealing with protocols, providing letters of claim and that sort of thing, all of them have inbuilt elements of delay, which are sort of unavoidable.
Absolutely.
So good solicitors, of course, can take steps to try and minimise those delays as much as possible, but it is a long process, isn't it?
It is, sadly, yes.
So another common misconception I think that many clients have is that their case inevitably has to go to court. Is that true?
Absolutely not. Such a tiny percentage of our cases actually end up in a trial. It's something like 3 or 4% at most. The vast majority settle along the way. Sometimes they settle relatively early. Unfortunately, sadly, sometimes they settle much later on in the process, but they do settle, whether it's by way of a settlement meeting or simply an exchange of offers in writing or over the phone or whatever.
And sometimes by mediation, of course,
yes.
Isn't it, bringing an independent mediator, although that's less common
yes.
in medical negligence, but is available if it's felt that it would be helpful. And turning to compensation, some people feel that awards of compensation for personal injuries and for medical negligence are a bit of a windfall. And what would you say to that?
Well, I think that's absolutely wrong. I think that's a really important, really serious misconception. I think the purpose of compensation from the client's point of view, from the claimant's perspective, the purpose of compensation is to put them back in the position that they should have been in if they'd never been injured. So you get compensation for the financial impact that the injury has had on you, whether it's loss of earnings, whether it's needing help to do things around the house or to look after the children or whatever it might be. It's to help you deal with those extra costs that you wouldn't otherwise have faced. Plus, there is an element to compensate you for the pain and suffering that you've experienced. It's quite modest in our system. Our legal system does not make generous awards for that. It's certainly not a windfall. You know, someone has gone through usually an extraordinarily difficult and distressing experience, and the money is really just to try and help them get back to where they should have been anyway.
Yes, I mean, it's certainly not a lottery win, is it? And most people would say they would much rather have their fitness and their health rather than the money.
Absolutely.
I suppose the other side of that coin is that many people are surprised at sort of levels of compensation and might think that the injury that they've suffered is worth millions of pounds in compensation, but the reality is often very different, isn't it? It
really is. Compensation for injuries, as I've mentioned, is extraordinarily modest in most cases. It's really often very much the smallest part of a claim, particularly when one sees reports of kind of multi-million pound settlements. The overwhelming majority of that money will be for loss of earnings for life, say. If you're dealing with a young person who's, you know, no longer going to be able to work because of the injury they've sustained, they might need 24-hour-a-day care, or at least a significant amount of care that they wouldn't have needed otherwise for the rest of their life. Yeah, so of those multi-million pound awards, usually a very, very small amount relates to the injury itself. Yes. Most of the money is as you say, to compensate for the financial losses and additional care, additional equipment and all that sort of thing. What about who can make a claim? I mean, some people believe, and it is a common misconception, that the only person who can bring a claim is the person who's been injured. And that's not necessarily so, is it? Not necessarily. I mean, I think if the person is still alive, then they are the person who would bring the claim. But if sadly someone's died as a result of the negligence, then their spouse usually, but not necessarily their spouse, it might be their partner. In certain circumstances, it might be another family member, can bring a claim on their behalf. And I think you've discussed fatal claims with Tammy on another occasion. And there's a lot of information, I suspect, in that podcast that would help on that issue. Sometimes you can incorporate claims for other people's time and support within an individual's claim. So if someone has needed a lot of help from their partner or from a parent or from somebody else, then we can include that care claim as part of the overall package, and that money can then be given back to the person who provided that support at the end. But that's very much an individual case-by-case situation. I suppose one thing that people may be thinking, that if they have an injury from which they have fully recovered, thank goodness, that they may not have a claim. And of course, again, that's not necessarily so, is it? No. I mean, if a full recovery has been made, then of course the compensation would be limited, but the ability to bring a claim may still be there. Absolutely. So it is sometimes worth considering that. What about the role of solicitors? Now, I think that taking legal advice is something which most people are quite nervous about. A lot of people don't really like to have contact with solicitors. It's seen as something that only happens in a negative part of their lives, and many solicitors, I suppose, as a profession, some of us have a pretty poor reputation, really, as being only in it for the money. Yeah. What do you think about that? Well, I would certainly say from our perspective, I don't think that's true. I think, you know, what we try and do is achieve something for the client that they would struggle and quite possibly not be able to achieve without us. You know, we take cases, certainly, virtually all of our cases are funded by way of conditional fee agreements, for example. So clients that come to us will pay nothing unless the claim is successful. If the claim is unsuccessful, it doesn't matter how much money and time we have spent in investigating, they're not expected to pay for that. But if the claim is successful, then they are asked to make a contribution. You know, they do agree at the outset to make a contribution towards our costs, which then enables us to carry on and to try and help other people in the same way.
I mean, as you say, I mean, I think that solicitors provide an expert service, which understandably, I think most people would say it is right that they should charge for. But I think the important thing is that our clients only pay if there is a positive outcome.
Yes.
And I think that most solicitors, yes, of course, they would expect to be paid, but the job satisfaction comes from achieving the good and positive outcome for the client. There's not a lot of satisfaction to be gained from failing.
No.
And so a positive outcome is good for the solicitor as well as for the client. So the next misconception that I'd like to spend a bit of time thinking about is misunderstandings about the impact of making medical negligence claims. I think there's a lot of information in the media about the negative effect, particularly upon the NHS, of medical negligence litigation. And I think some claimants may be put off from making a claim by the thought that somehow that they are harming the NHS by pursuing a claim. What do you think about that?
So I think one of the things that has to be remembered is the NHS is an enormous organisation. Things go wrong inevitably. What's really helpful, I think, and I believe in relation to medical negligence claims is it can highlight some of those areas where things are consistently going wrong. And it can, I think, ensure, or at least help to ensure, that something is being done about them. Because if nobody is complaining, if nobody is bringing claims, then it's much easier
I suppose for mistakes to be swept under the carpet.
Swept under the carpet, and not even intentionally, that people don't realise because they aren't pulling the statistics together because there's no need to.
Yes. I mean, and I think that, as in many areas of life, isn't there, when something goes wrong, I mean, there is an important issue of accountability, is that if mistakes are not addressed, then there's nothing to stop them happening again. And so identifying the reason for them and to try to deal with understanding it and working to prevent a repetition of it is really important. But I suppose that brings me on to the other aspect, which is that some people think that, and particularly maybe the medical profession, think that there's an unfair sort of blame culture, that somehow that there's an unfair retribution when they make a mistake. And I think that is a misconception that we do need to address.
Yeah, absolutely. I think that's very much not what we do. The vast majority of claims that are pursued, not just through us, but through most medical negligence solicitors, I think, are against hospitals and events that occur in hospital. And those claims are pursued against the hospital trust. They're not against individual doctors. They're not against individual clinicians of any sort. And so, we're pursuing a claim against the trust for failing to have appropriate systems in place to ensure that whatever happened didn't happen, shouldn't have happened. The trust may well then look at it and say, actually, this highlights an area of training, learning, resourcing that we need to address. But that's not what a clinical negligence claim is seeking to achieve. We're not seeking to have somebody punished, an individual punished for what went on. We're seeking to have a wrong put right financially in the only way that it can be.
So let's talk about some sort of emotional misconceptions surrounding medical negligence. I mean, one thing I sometimes hear is that people saying, well, clinical negligence claimants are only motivated by the money. Now, in my experience, I can't remember ever meeting a client whose sole motivation was financial. And in fact, I think it's far more common for people to come to us seeking answers.
Absolutely. That's almost inevitably, that's what my clients tell me. There are obviously situations in which they will benefit from the money. Most situations they will benefit from the money, but that's not why they come to see us. They don't want to be in this position. They're trying to understand what's happened to them, why it happened, how it happened, can it be prevented from happening again? And the money is very much a secondary or somewhere down the list.
Yes,
consideration.
It's not the primary motivation. No. The other misconception, I think, is that that the whole process is far too stressful. And I think some clients are prevented from seeking advice because they just think, well, it's all too overwhelming. The idea of pursuing a claim, it's just too stressful. I can't possibly do that all by myself. And of course, the role of a specialist solicitor is to actually resolve that problem for the client?
Yeah, I think inevitably it is a stressful process. I think it would be disingenuous of us to suggest that there aren't some points along the way when a client will feel, oh my God, this is difficult. But our aim always is to alleviate as much of that stress as possible. We will deal with everything we possibly can in conjunction with our client. We are a team, but we will take as much as possible of that stress, of that anxiety, of that concern away from them. We'll talk them through the process, reassure them about how it's likely to go, what's likely to happen, the points that are going to be difficult, so that they're forewarned, forearmed.
I think that's it, isn't it? I mean, a client should never feel that they're on their own in all of this. I mean, we're the experts in the process. We are very familiar with it. And although we can't shield the client from all of the stresses of it, we can stand next to them, prepare them and help them negotiate that.
Yeah, and take an awful lot of it off their shoulders.
Absolutely. So finally, thinking about some practical advice for people who are listening to us today. And I think that, I suppose at the earlier stage, if you're concerned about the treatment that you or a member of your family or a friend is having, I suppose while you're in the process, it's very difficult, but that there are procedures these days to allow you to seek or to ask for a second opinion in relation to the treatment you're receiving. So that's something that should be borne in mind. But the other point, I suppose, is that if once you're coming out of the process of the treatment, what advice can we give to potential clients about the sorts of things that would be useful for their solicitors?
What's really helpful for us is as much detail as possible about what happened, dates if possible. Timing sometimes can be critical.
So making notes.
As you go along.
While it's still fresh in your mind.
And that obviously can be difficult if you don't know at the time. Obviously, people don't know at the time that something is going to go wrong or is in the middle of going wrong. But as soon as you start to have concerns, try to make a note of everything that has happened as clearly as you can. You won't have everything, and we will, before long, be accessing medical records with the client's permission. So we'll be able to perhaps fill in some of those gaps. But the client's recollection, or someone close to them, their recollection of exactly what happened when, who said what doctors were involved, or what people were being told along the way, really useful, really helpful starting point.
And how about actually beginning a claim or starting the process of seeking advice? I mean, how do you find your way to the right person? I mean, that must be a question that a lot of potential clients ask.
Absolutely.
And of course, there are sources of assistance for things like complaints. All trusts will have a PALS service, a patient advice and liaison service, which is a good port of call for first steps in complaints and that sort of thing. And the next step, I suppose, is seeking expert legal advice and finding a way to a specialist solicitor. And how's the best way of going about that?
A couple of different routes. The Law Society, which is our sort of governing body, they have specialist accreditation panels. So look for someone who has accreditation in clinical negligence work. So that suggests they are genuinely an expert and not just someone who's having a bit of a go. There are other expert panels as well, the APIL, the Association for Personal Injury Lawyers.
And of course AVMA, which is a charity that's devoted to assisting people who are injured in healthcare. They also have a panel of specialist solicitors who they vet very carefully to make sure that they have the relevant expertise, but also the right attitude to assisting clients and getting the best possible outcomes. So there's all sorts of aspects that we've covered today. It feels like a very broad subject, but I hope that we have successfully debunked some of the misunderstandings and misconceptions about clinical medical negligence. And thank you for helping me with that today, Corrina.
It was a pleasure. Thank you.